In this section, we'll talk about chapters 26, 27, and 28. So in chapter 26, we're going to talk about the laws, the courts, and advanced practice nurses. So the sources of law, obviously legislation is responsible for passing law, regulation is responsible for implementing the law, and the courts provide interpretation and enforcement of the law. Regarding legislation, it derives from both Congress and state legislatures. They have different responsibilities that fall to each of them, and most healthcare issues are for the states to address, but the demarcation is becoming harder and harder to distinguish. Under the doctrine of pre-exemption, federal laws sometimes override state actions. Regulatory agencies are derived from the executive branch of government. They act on authority given through Congress or state legislatures to implement the law. The rules and regulations have the force of law. So things like the Board of Nursing, who help regulate nursing practice. Legislation would have been the Nurse Practice Act that governs us, and then regulation happens by the State Board of Nursing as well as the Board of Medical Examiners at times in states. And then the court system would look at the laws if they're applied in any kind of controversial situation and be able to, criminal courts administer criminal laws and punish wrongs in society, and civil laws look at controversies between plaintiffs and defendants. Just to look at the court system, there are 52 court systems, one in each state, the District of Columbia, and the federal courts. Most lawsuits are tried in state or trial court. If one loses at the trial court level, they can go to the appellate court, and the Court of Appeals or the appellate court can affirm, modify, reverse, or remand the earlier judgment. If you lose at the appellate court level, you can go on to the state Supreme Court. If the state Supreme Court refuses to hear the case, then the appellate court decision is final. And once the state Supreme Court renders a decision, that decision is final unless there are federal constitutional claims. And if so, then it could be taken on up to the U.S. Supreme Court. So what are some of the legal issues that we deal with? The scope of practice, and remember that each state has its own Nurse Practice Act that's going to define the role of the advanced practice nurse. Most of these are written broadly and do not involve the delineation of specific tasks. However, it is crucial that we look at the standard of practice for each state to determine what the scope of practice of the advanced practice nurse is at this time. Other issues that we may find legally that involve advanced practice nurses are fraud and abuse. So these could include billing for services that were not actually furnished, making false diagnoses to increase the payment, misrepresenting the services by upcoding, billing for services that are not covered, misrepresenting medical necessity, or billing under circumstances when requirements have not been met, such as billing incident to when a physician was not present. There are multiple laws that look at fraud and abuse in healthcare, including the HIPAA for healthcare protection and protection of health information, the Medicare and Medicaid Patient Protection Act, the Federal Anti-Kickback Statute, Federal Anti-Kickback Law and Regulatory Safe Harbors, False Claims Act, and the Omnibus Reconciliation Act. We talked about Incident to billing previously, but just remember, with Incident to billing, we would be billing incident to the physician and get 100% physician rate versus the 85% we would normally give. But again, in order for that to happen, the physician has to establish care, there has to be ongoing physician involvement, and there has to be a physician present at the time of the service delivery. So they can't be making rounds at the hospital or on their lunch break. Antitrust laws were put into place to assure free competition. Um, and so the aim is to protect consumer interests by things like not allowing healthcare providers to own DME companies and self-refer. So you have to make sure with the anti-kickbacks and antitrust that we're protecting the consumer and it's fair and equitable competition. Now shifting to talk about malpractice insurance. First, it was thought that nurses and advanced practice nurses would be immune from liability due to their employee status, and that nurses are held in high esteem by the public. Independence and autonomy was really discouraged, and compliance with employer policies was perceived um, as the most utmost of safe practice. And then as APNs began to gain autonomy, they became vulnerable to litigation um, as much as any physician. However, we do know that advanced practice nurses tend to be sued less than physicians. The risk for advanced practice includes judgments or settlements from a civil lawsuit, licensure or certification actions by boards of nursing or other private associations, or civil or criminal sanctions, or up to exclusion from federal healthcare programs for fraud or abuse. So, for civil lawsuits, that's why we carry malpractice insurance as a protective um, mechanism, so if we were to potentially be sued, that a family could be financially compensated if it rendered necessary by a court. The reasons why licensure or certification may um, be found as an issue that may be um, penalized could include false claims, overpayment, substance abuse, unprofessional conduct, or failure to have a written collaborative agreement if it's required by your state. And this may or may not be covered by your professional liability insurance. So, why would federal health program exclusion occur? Due to noncompliance with laws and regulations of those programs, and the penalties can be both criminal as well as civil. A conviction can be referred to the State Board of Nursing for action with respect to the licensee, and the most severe penalty would be exclusion from all federal health care programs, such as Medicare or Medicaid, that you could not participate in. This is generally not covered by malpractice insurance, and if you're convicted of a crime related to the delivery of an item or service paid for by a healthcare program, if you were found to be fraudulent with extreme fraud, you could be excluded from federal healthcare program inclusion, so you wouldn't be able to accept Medicare or Medicaid. And this would probably cause most healthcare agencies to not hire you because they're all take Medicare and Medicaid, or either or. The National Practitioner Data Bank was implemented by the U.S. Department of Health and Human Services, and it has information on the disposition of all cases and malpractice payments, as well as any adverse licensure, clinical privilege, or professional society actions. The Healthcare Integrity and Protection Data Bank also collects reports and discloses information regarding licensure and certification actions, program exclusions, criminal convictions, and other decisions against both individual practitioners as well as institutional providers. So, what are the trends in malpractice claims? The number of nurse malpractice payments is growing. Two-thirds of claims have been made on behalf of RNs and not advanced practice nurses. The advanced practice nurses that have been included the most are CRNAs and nurse midwives, and the highest number of claims were reported in New Jersey and Texas, with the lowest being in Delaware and Vermont. Tort reform is very important because it helps to make malpractice insurance affordable and limit the number and size of claims. So it does put a limit on how much somebody can sue for. When looking at insurance, you want to look at the occurrence, which is the policy was in effect at the time that the incident occurred, or the claims made, which is the adverse event um, must have occurred and claim made during the policy period, versus tail coverage is necessary if you have claims made insurance, because tail coverage will give you coverage after, even if you're no longer currently working at that facility or covered by their malpractice. So, what are some defensive actions to minimizing your malpractice risk? Always being professional, following standards of care, delivering quality of care, and documenting those actions. Another way to manage risk is through positive relationships with patients, their family and friends, staff, and other physicians. Open and full communication is permitted. Be truthful, honest, and respectful. Incorporate them in patients in the decision making process as much as possible, and explain things in understandable terms to patients. So let's talk about what happens if you were to be sued. You're going to get your insurer involved. You're going to need access to legal counsel. They may try to do a settlement before they actually have to go to trial. If no settlement can be reached, there would be a formal trial, and it may include expert witnesses to produce information about standard of care. In a lawsuit, burden of proof lies with the patient, and evidence must prove duty, breach of duty, causal connection, and damage. And listed below are some more additional um, tips for managing your risk of liability. Last, we'll talk about ethics and its role of advanced practice nursing. Even though we think of our profession as ethical, experience and knowledge alone don't ensure the development of an ethical practice. We have to be responsible for ethical decision making and action in healthcare, requiring awareness and understanding of the context in which the decision has to be made. Be sure to look over the terms related to ethics, such as autonomy, freedom, and objectivity, as well as self assertion, beneficence, and fidelity.